You may proceed.
Mr. Inambao, can you please go to Manual 2? Hopefully I want to see if we can finalize this agreement. Page 256.
I'm there.
I think you have read a few of those clauses.
I'm there.
All right. In the fuel industry, one of the ways to secure exclusivity is to build tankers on someone else's property. Do you know that?
We did discover that during the investigations.
All right. If you look at point 3.1, that is basically giving, NAMCOR exclusivity in terms of those tanks. Would you agree? I will give you time to read.
3.1.
3.1, yes.
Following the transfer of ownership of the assets to NAMCOR Trading, pursuant to this agreement, NAMCOR Trading hereby authorizes ENACON to utilize and store only the petroleum products procured from NAMCOR Trading for the duration of the supply agreement between ENACON and the Ministry of Defense, subject to the terms of this agreement unless this arrangement is terminated earlier by NAMCOR Trading for whatsoever reason.
It means that ENACON can only use fuel from NAMCOR in those tanks.
Your Worship, in terms of our investigations, this agreement was simply an instrument that was used to ensure that the money is moved, rather laundered from NAMCOR Trading to ENACON and subsequently to the staff members or former staff members of NAMCOR, including Mr. Cedric Veremse, Your Worship. So these conditions were simply embedded there just to ensure that the transaction of the money is able to be concluded from the books of NAMCOR.
But Mr. Inambao, I did not ask you what is the reason for this clause. I just asked whether that is the meaning of the clause. Did you hear the question?
Well, in terms, I don't know which answer you want to give. You want me to give you. As far as I'm concerned, that is a suitable answer.
Okay. So the agreement was used as a vehicle.
Definitely.
So is the agreement valid?
When an instrument has been used to commit an offense, I cannot confirm as to whether it is valid or not. What I'm saying is it was used to commit an offense. This was a vehicle. That is why there are charges of conspiracy in this regards. Because both ENACON and the concerned staff members conspired, and the only way the money could be funded out of NAMCOR is through ensuring that there is a contract.
So your answer to my direct question, whether or not the contract is legal, is that you don't know if you can't say whether it's legal or not. Is that your answer?
I'm not going to be able to define whether this is legal or not. But if you were to ask me as to whether the people who signed this did sign it, yes. But we are saying they simply fabricated it to ensure that the money goes out. That is why, even some of the conditions, terms and conditions are in this way.
Mr. Inambao, did you not on the previous bail application, under oath, confirm that the agreement is legal? And you must remember now you are under oath.
I am under oath, and I don't know whether I've testified to that effect. You have asked me a question, and I'm telling you what the evidence have concluded.
Your Worship, I have to object to that line of questioning. I do not know whether, for the purposes of this bail application, it is fair to use what the witness had said in the other bail application, because we are dealing with a fresh bail application altogether for the applicant before court. So to tie the witness to what he had said in the previous bail application, I think it's unfair. It's an unfair question. I think it should just be confined to what we are seized with at the moment, not to say in the previous bail application you had you had said this.
Bishop, the witness also made reference to the previous bail application. My learned friend is my learned friend saying that in one application you can say A, and in another application you can say B? Is my learned friend saying that the new application give a right to his witness to change his mind? He was under oath when he said that.
I will allow for the question, but what is the question that the defense is asking?
I'm asking, did he not say and agree that this agreement was legal? Because what he's saying today to this court, again under oath, that he said he must not lie, is that the agreement is not legal. That is what I'm asking him.
Your Worship, I have answered the question. When I prepare, I don't go and prepare based on the previous formal bail application, and I've never made references to that application, Your Worship. I have provided evidence to this court from the findings of investigations, and I kept saying in terms of the evidence, Your Worship, and I will repeat this, even in the other application, I said this contract was used as a vehicle to ensure that money is laundered from NAMCOR.
But I thought you don't want to refer to the previous...
You wanted me to refer to it, and I'm just simply repeating and confirming what I said.
Yes, and I'm also asking you to repeat and confirm what you said. In the previous bail
Okay, it has
application...
been answered. Can we move on to the next question, please?
Let me ask you this. Did NAMCOR think this is a legal document?
NAMCOR was, a misrepresentation was made to NAMCOR Trading.
Bishop, at this point I must ask. It's a closed question. Very simple question that I asked this witness. And I've been patient.
Okay, what is the question, Mr. Isaacs?
Did NAMCOR think and confirm that this is a legal contract? That is my question.
And I was about to answer you, Your Worship. My answer I'm saying is, misrepresentation was done to NAMCOR. Hence, Your Worship, NAMCOR, after conducting internal investigations, they came and report a case. ACC did not go to them. NAMCOR, on their own accord, based on their internal investigations, found elements of such and reported the criminal case.
Does that answer the question to the court?
Do you want a yes or no answer? Is that what you want?
I want
Mr.
to know
Isaacs?
whether NAMCOR, I didn't ask, did they report it? I simply asked him, did NAMCOR say the agreement is legal or not?
Your Worship, the fact that the case was reported, it means misrepresentation was committed.
All right. You agree with me that in 5 October 2023, NAMCOR wrote a letter to NRCON that they will cancel the agreement. It's valid until such time as they are refunded. Are you aware of that?
Your Worship, I'm aware of the letter, but I cannot confirm whether it was indeed on the 5th of October 2023, if I haven't seen the letter, Your Worship.
Now let me take you to the letter. Page 199D. 102.
Page
199, capital D. I want you to, are you there?
I'm there.
Is the court with us?
Yes, I am, but just the person that is behind there walking with their feet. Please, we are in a court. You cannot be walking without shoes. You may proceed.
Paragraph 5, can you please read it into the...
Paragraph 5, we hereby reiterate the fact that the asset purchase agreement between the parties thereof remains intact, valid and binding until such time as the conditions of the reimbursement of the funds as stated under clause 2 above is met and the settlement agreement is signed between the parties.
Which date was that?
5 October 2023.
Right. I want you, the court, refer the court to page 242 of bundle 2. Mr. Inambao, what is that? That is on page 242.
It's written NAMCOR Asset Register Fuel Storage Facilities and Installations Modiva sites.
Yes. And in the corner, right-hand corner, there's a stamp.
Ducatus Financial Consultant CC.
All right. Does this document relate to the 9 storage facilities?
I believe it does.
All right. The purpose of the asset register is to confirm ownership, correct?
Partially, but if one wants to really verify the asset register, one needs to look at the financial statements of an entity, which would list the liabilities and the assets owned by that entity.
Question. When you say partially, what does it mean? Is this document valid? Or does it show, just wait, does it show ownership of an asset?
This is a document which is written by an accountant or an accounting firm indicating these assets are in the asset registers of NAMCOR.
Meaning if something is in your asset register, does that not make it your property?
I cannot rely, if, given me where I'm standing from, yes. I cannot rely on this document alone. No, there needs to be financial records of that entity proving indeed this asset has been in their financial registers from this period until this period. Yes. But in this regard, this document was simply created to satisfy the requirement
of ownership.
Of ownership.
All right. But luckily, you are not the person that need to determine it, that is the court.
Of course, my duty was to conduct investigations and obtain evidence.
Yes. Mr. Nambao, is it common cause that the asset purchase agreement was given birth to by a fuel supply agreement between NAMCOR and NRCOR?
I believe it was part of the plan which we are talking about, the conspiracy which started way back in October 2021.
You said the conspiracy started in October 2021.
That's correct.
What happened in October 2021?
That's when an account for NAMCOR was opened in which the strategic executive finance was given mandate to. And in that account, that is where Modiva was supposed to be paying money, and the money didn't go there, all of it in its entirety.
Okay. In October 2021, where was Mr. Williams employed?
I believe he was a consultant at NAMCOR.
All right. Did you have any negotiations or any input in the opening of that account in terms of your investigation?
No, but we cannot confirm that because we know that on 22 April, before he was appointed in the permanent capacity, there's evidence indicating he was involved at least in the negotiations of the assets. The asset which was given birth by the fuel supply agreement.
See, Your Worship, my question was simple. Was he involved in October 2021 with the drafting, negotiating of the supply agreement? That's all. That was my question.
Was it not answered?
It was answered, Your Worship, and then the investigation go on and on about the asset agreement. I have to ask him about that. But if the court allows him to testify about
Perhaps
others,
then you can
other
say
than-
if you want a yes or no answer, because you're asking, does it have, you're asking an open-ended question. He answered it. If you don't want him to answer any further, perhaps you can say, answer me yes or no.
Your Worship, I can guarantee the court now that answer will not come as yes or no, but I'll try. Can you please give me a yes or no answer, Mr. Inambao? Was Mr. Willemse in October 2021 at any stage involved in the opening of that account?
No, he was not involved.
Thank you. I want to go to the the fuel agreement. I believe it should be page 159. Volume 2. Bundle 2. Are you there, Mr. Inambao?
I'm there.
Thank you. Can you please go to clause 4.5.1? Sorry, not that one. Sorry, there's two actually. 16 on page 164, correct?
Yes,
Are you there?
164. I'm there.
All right. Can you please read that into the record?
You said 4.5.1.
Yeah, 4.5.1.
The seller and the buyer to enter into negotiations with respect to the purchase of all assets, pumps, canopy, and tanks and related equipment belonging to the buyer, hereinafter referred to as equipment, at a market-related value to be established by the parties' joint technical team. The parties further agree to negotiate with a reasonable time, within a reasonable time, an amount that could be set off against debt owed by the buyer, if any, at the time of negotiations with regards to the acquisition of the equipment.
Yes. Do you agree or do you not agree that that gave rise to the asset purchase agreement?
I partially don't agree, because when EcoFuel ceded the debt of 73 million to Enacon, there was a resolution in which Enacon had first, in that resolution, among others, indicated they needed to enter into a fuel supply agreement with NAMCOR, or rather, Enacon should enter into a fuel supply agreement, among others.
All right. So that agreement or that resolution plus this agreement would then give rise to the asset purchase agreement.
That's correct. Okay. Which was part of the plot, which already was initiated in October 2021.
Yes, we will come to the session agreement. Just for the record, when was this agreement signed?
16 March 2022.
Yes or no question. Was Mr. Willemse involved in the negotiating or drafting of this particular agreement?
As far as the evidence is concerned, I didn't testify that Mr. Willemse was involved in this. So our evidence could not find evidence that he was involved in this agreement.
And there I ask a yes or no question. You would also agree with me that this agreement was concluded before what you term, there was an allegation, or rather email sent in April 2020, we said 2022 or 2021?
2022.
2022. So this agreement was before that email.
That agreement, or that communication, Your Worship, actually goes further to show the involvement of Mr. Willemse even before the email was sent. Because it goes to show that he had knowledge of these engagements. Otherwise, he would not have been involved, or he would not have been in the position to suggest what should be contained in the internal memo that was written on the 8th of July.
Okay. Do you confirm, yes or no, that this agreement was before the April email that you claim was sent?
Your Worship, it's very difficult for me to answer a yes and no question without cementing the rationalization as to why I am saying yes or no. And in this regard, I believe I said yes and provided the rationalization therefore.
Okay. We know for a fact that in March, as you testified, 2022, Mr. Willemse was not a permanent employee of NAMCOR.
That's correct. In a sense that he worked as a consultant. So in a way, Your Worship, he still served the interests of NAMCOR.
Okay. You further testified when this asset purchase agreement between NAMCOR and NRCON was entered into, there were no procedures followed. Absolutely nothing. That's how I understand your testimony. Would that be correct?
No procedures were followed other than coming up with these documentations which we believe they were fabricated in order to ensure money moves from NAMCOR.
Yes. Now, you are aware that before this agreement was entered into, there were certain procedures followed, boxes ticked. Are you aware?
That I cannot confirm until you lay the procedure, those processes that were followed. But as far as investigations is concerned, the procurement process was not followed, financial and policy procedures was not followed, there was no board approval, there was no budget. So I don't know what you are talking about when you are saying there were boxes that were ticked.
Let me enlighten you. The first box that was ticked is there was a verification of the existence of the asset. Because you testified that the MD sent 2 people from NRCON to see if they existed. Is it correct?
I have never argued that there was no verification. The
Is it
verification,
correct, sir?
the verification was there, was done.
Thank you. The second box that was ticked was ownership was confirmed through the asset register as well as from NRCON.
Although it was confirmed, I've stated my position. As far as I'm concerned, there is no financial records indicating these assets indeed were in the books of NRCON since 2016, when they entered into the agreement with NDF.
When you say financial books, what does it mean?
The financial statements.
Do you have the financial statements?
As far as we are concerned, there's no financial statements.
So you don't have it?
We don't have it.
So the fact that you don't have it doesn't mean it doesn't exist.
I'm saying this document alone does not satisfy the requirement of indicating that these assets has been in the asset register of NRCON. Because with your financial statements, they would have shown from 2016 that these assets existed. So this is a record that was created on the 15th of July,
Yes.
2022. So that is the only account that we have.
I know. My question is, the fact that you don't have it, does it mean it does not exist?
No.
Thank you. The third box that was ticked is that there was a feasibility study done. Would that be correct?
Yes, the feasibility study was done on instructions of Mr. Willemse.
Yeah, we'll come to that. Did Mr. Willemse instruct the MD, Managing Director, to authorize the two employees to go verify the existence of the asset? Yes or no? No. Thank you. Did Mr. Willemse, or was in a position to verify the truthness of the asset register that was provided by NAMCOR?
I cannot confirm that because I have never provided evidence indicating that he verified the asset register. What I testified on is that he certified the invoice.
Yes. But Mr. Mbao, I will come to that.
Yeah,
I'm just
and
I'm
still proceeding with my answer.
Okay.
However, you need to note that on the 22nd of April 2022, the list of these assets was sent to Mr. Willemse. So meaning Mr. Willemse, and I'm saying meaning this, it's upon these documentations that an internal memo was prepared by the engineering team for them to undertake this travel itinerary to go and conduct an evaluation.
Mr. Mbao, unless we see that invoice, that email, that is not true.
And I'm telling you, that is the truth.
Yes.
Evidence is there.
Okay. But we know for a fact that Mr. Willemse was not involved in the verification of ownership or existence, verification of ownership, and he was not the one that physically did the feasibility study. That is undoubtedly so.
Your Worship, the staff member who conducted the feasibility study, I believe, is a staff member who has a junior rank versus the rank that was occupied, or rather the position that was occupied by Mr. Willemse. Yes. It's a known fact in business that senior managers can instruct their subordinate or junior staff members in a specific area for them to undertake that activities.
Is it also a known fact that the MD can instruct his subordinates to do something?
Of course.
Thank you.
And that is why, including his, the managing director has also been charged and is a suspect on the case in this regard.
I didn't ask you that, but thank you for the information. Now, for which department is Mr. Ashela? Did he work?
I believe he worked under finance.
And who's his boss?
Ms. Hamokwaya.
And who's her boss?
Technically would be the managing director.
And who's his boss?
The board.
I haven't heard Mr. Willemse's name in that chain of command. Is it correct?
Even if you haven't heard his name, you have seen it on the emails that we produced. You see, the fact that his name is not in that chain, yes. He was still a staff member, he was still, he was very active. If there was no evidence placing him on the scene or placing him in doing those activities, he would not be here.
Yes. And if he's asked by the MD to do that, why is he here? You just said the MD can do that. Why is he here?
Why is he here?
Yes. If the MD instructs him to guide the process, why is he here?
He's an accused person.
Oh.
He's here because he's an accused of the offenses and the charges that he's been charged with.
Yes. You know, what I find strange Mr. Inambao, is that when Mr. Willemse testified, this specific aspect was brought up with him. He denied that he instructed Mr. Scheller, and he was never cross-examined on that fact. Do you find it strange?
I don't find it strange, Your Worship. If he denied, we have provided evidence indicating even the discounted cash flow report was sent to him. I believe that is far better evidence than having cross-examined him on that aspect.
Yes.
Because the evidence shows it was sent to him, and from there he gave instructions.
We'll come to the emails. Now, you also talked about budgets. Do you hear me when I say that there were two budgets, operational and capital? One for business development and one for asset acquisition.
Your Worship, during the investigations, we spoke to the financial managers within NAMCOR, we spoke to the board, and they provided us the consolidated approved budget for NAMCOR. And they pointed out as to which part of the budget was budgeted for asset takeovers.
Yes, I hear you.
And in this regard, Your Worship, it was 25 million, and that document was given as part of the evidence for the financial year 2022-2023.
Is it possible that one can take from one vote money for the purchase of an asset if it's above the budgeted amount?
Your Worship, it's correct, provided the procedures are followed.
Yes.
Meaning, budget needs to be reallocated from one vote to another. Yes. And the board approval for that to happen is required before the expenditure is undertaken. Also, budget verification was also required.
Yes, we'll come to that. I just want to first deal with the movement of votes. Let me take a step back and ask you whether you confirm there were two different budgets.
I answered that question. I said one budget, consolidated budget, was provided for investigations.
Together.
I'm saying it's a one consolidated document that was provided. So, and on that document, it lists all the items. So, in fact, that document was presented before the court.
Okay.
So, and I believe Mr. Cedric was able to provide where the other funds were moved from.
Yes, Mr. Cedric's instruction is that there were two budgets. Do you deny that?
I deny that because we were provided in terms of evidence the budget of 25 million as the one and only budget that was made for that financial year in terms of asset takeover.
I'm not referring to only asset takeover, sir.
I believe I've answered your question, Mr.
Okay.
Isaacs.
Who approves budgets?
The board.
Is Mr. Willemse part of the board? Or
No.
was?
No.
All right. You confirm that money may be moved from one vote to another, and this need to be board approved, correct?
That's correct.
Who must do that request to the board?
I believe, or in terms of the evidence that we gathered, that would have been motivated by the executive. In fact, it would start with the business unit that is procuring services, and then from there it would go to the executive finance, eventually the managing director. That process would have to be followed, and eventually to the board. And then from there, a consideration is undertaken as to whether that reallocation is approved or disapproved.
Okay, great. So, Mr. Willemse was not a, as you said, a unit manager, correct?
Mr. Willemse, at the time of acquisition of the assets, he was the manager, logistics, supply and logistics.
But
although he did not, he was not the author of the internal memo, he directed Miss Olivia from sales and marketing how to handle it or how to prepare the internal memo, requesting for such services. In this regard, Your Worship, we believe he should have also advised on the aspects of the budget, advised on all the other components, the board approval, and so forth and so on.
So he's allowed to advise, although it's not his department.
The same way that he was able to tell Olivia what to do.
Okay. Let's just step back for a moment. Just mention the people's names that need to go to the board. You said what manager?
I said it was the user department in
Just hang on. User department. Which department?
sales marketing, where in this regard Ms. Olivia was the one who initiated the request.
Okay. In other words, Mr. Willemse is not in that department.
That's correct.
Then it goes to the executive finance. Who was that?
That was Ms. Jennifer.
So Mr. Willemse was not didn't co-act with the executive finance, correct?
That's correct.
Then you said it goes to the MD. Who was the MD at the time?
Mr. Mulunga.
We know that Mr. Willemse was not the MD at the time.
That is known.
Right. So the people that had to ensure that there's board approval from one vote to another is these people, but there was no obligation other than you say advice on Mr. Willemse to get board approval, correct?
Hence we are talking about conspiracy. And you know, this word conspiracy, I will keep repeating it, is because they planned, including Mr. Willemse. Otherwise, he would not have had any footprints or fingerprints in that transaction.
Yes. How did he plan to tell people they have board approval? What did he do?
I indicated already. He is the one who directed Miss Olivia to draft the memo and the content of the memo.
Okay.
Part of that, when he's the one who directed the creation or the generation of the discounted cash flow report. And from there we know that, you know, despite processes not having been followed, you know, at the end of the day, he was in a position to be a checker of the transaction. At the point when the contract had already been signed, he is the one that ensured that the invoice was certified correct. And by certifying the invoice correct, it means the due processes and all the other processes involved should have been followed. At that point in time, he needed to check where is the board approval, where is the budget verification, and so forth and so on. And he could have asked questions at that point in time if those were not there.
Where does it say so that that is the process that he must follow when he signs an invoice? Take us to that part. Let us not talk out of opinions. Take us to the document where it says, wait sir, that it says that before signing an invoice, you have to check A, B, C, D. Take us to that part.
I might not be able to take you to the document which says like that, or refer you to that piece of the policy. But in terms of the interviews that we conducted with the staff members, that's what they indicated. This is the process that has been followed. Yes. So the checker needed to verify those.
Yes, I'm with you. But you, in the absence of, you cannot provide us with any documentation. As my learned friend asked Mr. Willemse, show us where the board said, or that Ms. Jennifer went to the board, bring us a document or something. And he was asked that. The same of you.
No, the
you cannot provide any evidence before
the policies
court.
are there.
That is the procedure.
The policies are there.
Policies are there, yeah, indeed. Now, you said there's a budget verification. Where is it? Which document must I go to?
There was no budget verification.
No, I'm saying there must be. I am with you.
Yes, I believe it will be in the financial.
Where is it governed?
I believe it will be in the financial policies and procedures.
Just show the court where it is. So the
Your
court
Worship,
can also see.
At the moment, I'm not able to do that, but the policies are there which guides how payments are undertaken. And when we interviewed staff members, they confirmed of this. And when we go to trial, these staff members would go and testify on these aspects.
Yes, but for now, I put it to you, you have no evidence to say what you are saying. It's simply your say-so. You talk about policies, it's not before the court. It's in the policy, it's not before the court. You say, let's do it at trial. That is what you say.
That's what you are saying. As far as I'm concerned, is we have obtained evidence, we have obtained pieces of policies, we have obtained all these kind of things, and it was indicated as such.
All right. Coming back to where you testified that Mr. Willemse instructed Mr. Sheila to write this report. You said that is contained in an email.
But when the email was sent, when the report was sent,
You said it's contained in an email. You referred me to an email when I was cross-examining you about it.
I am answering you.
Okay.
When the report was sent, it was sent via email. But there were meetings that were held between Mr. Sem and Mr. Willemse,
Okay.
in which the instruction was given for the generation of that report.
Great. When was that meeting?
Your Worship, right now I cannot say, but it's after the report, the evaluation report was created. And if you look at that chain of email, the one I believe is for 6 July, where the report was shared with Mr. Willemse, I'm sure those conversations will be able to indicate otherwise.
What do you mean otherwise what?
Indicating that the request to, when the report was finalized, it was sent to Mr. Willemse.
Yeah, I'm still busy trying to find out the meeting. So who was in that meeting? When Mr. Willemse instructed someone that is not working in his department to do the report. Who was in the meeting?
I indicated that Mr. Mukwaya was there, who is the direct supervisor, I believe, at the time of Mr. Ashela.
Who else?
For now, those are the names that I've given you that I know.
Makwaya, and his Willemse, and then Mr. Ashela. I assume, safely so, in terms of proper governance, that there are minutes of these meetings.
I would like to believe so.
In
In fact, during the evidence, Your Worship, we were able to put our hands on a transcription that was of a conversation that was recorded between Mr. Willemse and Mr. Hashela, which is part of the evidence in which this discussion took place.
Okay, so since June 2024, were you able to obtain these minutes?
I just indicated we have this. We have it as part of evidence. We have taken statements from the individuals that we are talking about. We have interviewed them.
Mr. Nambao, there's a difference between taking a statement, really, and minutes. Do you understand the difference?
Some meetings are not minuted, and hence I referred to a transcription of a recording that had happened.
Where's the transcription of the recording?
We have it in terms of the evidence.
Do you not have it?
That is not the question you should be asking me, because I'm not the one disclosing evidence to you.
I see. In the absence of that recording transcribed, what we have here is you telling the court there was such a meeting, correct?
That's
Or
correct.
something someone else told you, correct?
Not somebody else told me.
Shala.
I have seen the transcription. I have taken the statement. So this is not a mere hearsay. This is evidence that we have.
No, sir, it's hearsay.
No.
You were not in a meeting, you are not the author, it's hearsay.
But even if it's hearsay, during the current application we are having, I believe hearsay is admissible as well.
Indeed, until such time as it's disputed, that's also part of the law. Mr. Nambao, it's the first time that we hear about this recording. Not once did the prosecutor put it to Mr. Willemse. But Mr. Willemse, you asked for a meeting. We have recordings to prove that you asked for that meeting.
I don't know whether you expect me to answer that question. I'm not the one who dictates what questions the prosecutor puts to the applicant.
Okay. Now, which email did you wanted me to have a cite on in terms of the email that was written to Mr. Willemse? Which one is it you're referring to?
I was referring earlier to a conversation which happened between 6 and 7 July. I believe those were handed to the court.
Is it
I don't know whether it was
F1?
yesterday or today.
I don't seem to find my copy. Pierre. You still have the emails in front of you?
I'm only having the purchase orders here.
No, I'm referring to the emails.
That one I don't have. I'm only having the purchase orders emails here.
Okay. You were provided with a copy of the email yesterday, correct?
Come again?
You were provided with a copy.
I would
of
like
that
to believe
email.
it was handed in as evidence.
Which I think is it not F1?
The emails are from Exhibit G1 to
Or G1.
G3.
If I may just get a site of the court's copy to see. I don't know why I made mine F1.
Okay, it starts from F1.
Yes.
Which emails are you referring to? The
Yeah,
July
no, this-
2022?
Yeah, these ones are.
Okay, then it is
G1s are the
F1?
ones that. Thank you. I don't know if. Seems to be the witness does not have his copy. See if I can quickly find it. That email from where was it sent from, Mr. Sheila?
I would like to believe so, Your Worship, but I can confirm when I have the document in my hands.
Can I then have the
Where's the
exhibit?
court's bundle? Where's- I think it shows 3-1 in the corner. Can the officer just verify that we have the same email? Because it was just as a group and not page 1, 2, 3, 4, 5.
Yes.
So just trying to.
This one.
Is it not the correct one, Mr.?
No, I have the two correct ones here.
Yes, but the one that I showed you, does it form part of it? That comes from Mr. Sema Shela.
Well, the chain of the emails that I'm having here. Okay, there's this one, I believe, perhaps, maybe this page is also part of these documents. Yes, it looks like it's part of these documents because I see Mr. Petrus Ainiko in the, yes, Sam Hashela. No, definitely this page is one of these.
No, that document that you have there is not part of the document. I found it in my bundle. It cannot be part of your document.
I have two documents which are the same, and this one which is alone.
Yes, that document that you have it now
This one.
is one that I gave to you now. It's part of yours. Do you understand? You must give it back. I don't know.
You gave it to me. I thought you want me to keep it so I can make references to it.
No, I wanted you to compare that email with the ones that you have, whether that email is also part of your bundle.
Yes, it is. It's part of this this one.
Okay.
But just give me a second. But not part of this one. I think it's a page which is missing from this one.
Okay. You mean, do you have a copy of the same emails?
Yes, except that one page which is missing from this set.
Okay. Now, can you go to the email where you said that Mr. Willemse instructed Mr. Scheller to draft the report?
Your Worship, I said the report was sent to Mr. Willemse, and yesterday when I testified, I indicated, or I went to the email on the third page of this exhibit.
I don't want to get confused. There's no email stating that you have in front of you instructing Mr. Scheller. That we have.
Hence, I said there was a meeting.
I'm asking, in the emails before you, there's no email where Mr. Willemse instructed Mr. Scheller. Is that correct?
That's correct in terms of the emails, but there was a meeting.
Right. Now, what is the response, of Mr. Scheller? What was the content of his email? Can you
There's a number of emails here. Maybe you need to be specific as to which one you want.
Mr. Scheller, only his email. What did he say?
You see, if I go to the beginning of this thing, I believe which is page number 4.
Yes.
You would see that Mr. Scheller was writing an email to Ms. Jennifer, and copied in this email was also Mr. Willemse,
Okay.
in which Mr. Scheller was asking, what financing assumption should we base our assessment on the investment?
Great. Who did he ask in that email?
He was asking his supervisor, because they are from the same department of finance, meaning in terms of the methodology that needed to be followed. It's his supervisor and him who were aware of this.
Mr. Scheller, please. In that email, who did he ask the parameters from?
I don't believe these were parameters.
Or whatever the email was. Who
Yes,
did he
this was
address
a question. This was a finance question which was asked. Hence, he asked the finance question to his supervisor,
Who is that?
Ms. Amokwaya.
So he didn't ask Mr. Willemse.
Yes, but he chose to respond.
Okay. So Mr. Willemse responded. What did Mr. Willemse say?
Since Jennifer is on leave, and since we had deliberated on this will be totally self-funded and has been budgeted for.
Great.
So no debt financing.
Okay.
Which goes to show that there was a meeting which I've been talking about. Hence there were deliberations.
Yes. But that meeting in that email referred to not the instruction to do the report. Do you agree?
Everything here relates to the report. You can even check the subject of those emails. Enacon asset DCF.
So it doesn't say, it said that we discussed not that in a meeting where Mr. Willemse instructed me. It doesn't say that.
No, that is Mr. Willemse responding and confirming there were deliberations.
Right.
And we have confirmed with Mr. Scheller in this regards, who confirmed Mr. Willemse was there. In fact, it's him who had organized the meeting.
All right, thank you. We respond to ask Jennifer about it, and then Mr. Willemse respond. What was his response?
Whose response?
Mr. Scheller. What is his response?
Dear all, here attached, please find the asset takeover DCF as requested. The comments are provided on the feasibility study result.
Okay.
The copy that I'm having, unfortunately, it cuts out the name as to to the recipients, I just want to verify here. I believe this copy as well, but I believe included in this email is all the individual. It's Mr. Jennifer, it's Mr. Velemse, and Ms. Dunaiski.
You believe? What does that
I'm
mean?
saying so because they have all along been there. At least.
You say you believe. What does it mean? Without any evidence, you say you believe.
From the emails, the original emails that we have, I know Mr. Cedric is there. It's not about believing here. Jennifer is there, and as well as Olivia is there.
So the prosecutor gave us a bad copy.
I don't think if it's a bad copy, it was his intention, because it's a copy which he omitted to copy some other information.
All right. In that email, he does not address Mr. Willems individually, correct? That's what you just read. It said, "Dear Ting."
That's correct.
Okay.
And hence we are saying there is conspiracy, because it was not only Mr. Velemse, and I've been directing the conversation to Mr. Velemse specifically because he's the applicant that is sitting before the court.
Yes. Yeah, Ms. Ashela is not sitting here, and all other people that are also similarly involved, they are also not sitting here. Correct?
Correct.
Yes. In that email that you read, it referred to the word instructed, as instructed.
Yes, which confirms what I have been saying, because he was instructed.
It doesn't confirm what you're saying. Does it say instructed by Mr. Willems?
Your Worship, in the statement we obtained from him, he confirmed he was instructed by Mr. Willems, and we asked that question, who instructed?
Yes, I'm not dealing with the statement that's not before the court. In the email that you read, does it say instructed by Mr. Willems?
Your Worship, in addition to the information from the email, from this email, I can confirm that it was indicated Mr. Willems was the meeting organizer and the instructions came from him, or rather the request.
Mr. Inambao, my instructions from the applicant is that his involvement regarding the drafting of all documents that led or negotiations that led to the asset purchase agreement, his involvement was requested by the MD. Can you dispute that fact?
I cannot dispute that fact, and hence, because of everything that happened, including the MD then, he's a suspect on the case.
Yes.
So, and hence we are saying they conspired. It's good you are mentioning that, because it just shows that indeed they were planning to do these things.
So, in other words, would you agree with me, he did not misrepresent to NAMCOR that he had his involvement in this agreement, correct? Prior to the agreement.
No.
There was not a misrepresentation.
No, there is. If you
Can
look,
he misrepresent if he says?
I wanted
if
to
you
answer
agree-
you. Because if you look at the email on top here,
Yes.
the one of 7 July, Cedric further writes, please note that we want to present tomorrow to MD. The second sentence, also please slide in the submissions. Our ultimate goal in this process is to step closer to the direct contract with MOD.
Okay.
So I believe that was misrepresentation.
What was misrepresented?
NAMCOR never got closer to that deal until today.
Oh, I see. Oh, that's the misrepresentation. I understand.
No, what I'm trying to say is, these ideas came from him. So whether he was requested, if he was requested by the managing director, there would be evidence in which the managing director at least was part of the correspondence in the first place, or there will be that instruction. Hence we are saying in this regard, they conspired.
Mr. Inambao, you just read there in that email that the reason why they need the documents is for the MD.
Yes.
You just read it there.
Because they conspired.
Oh, now they conspired. Okay.
And I've been saying it all along.
So, when all these documents are gathered, who must now decide who has the authority to enter into the asset purchase agreement?
That is a non-fact. The managing director, in terms of his position there as the managing director, is the person that enters into agreements.
Okay.
But as I've been saying, we must not forget that these instruments were simply created in order to make the transaction look legitimate.
Yes. And then don't forget the conspiracy.
Of course.
Yes. Let's talk about the memorandum, or office, what do you call it, internal memorandum that was sent. Internal memorandum of 8 July, you will find it on 202. 249, sorry. It's another memo.
I'm there.
So, to whom was this memo written?
The memo was going to the director, to the managing director, at the time Mr. Mulunga.
And the date of the memorandum?
8 July.
And it came from Ms. Olivia Dunaiski, correct?
That's correct.
Now, the purpose of this internal memo was for the approval of the asset purchase agreement, correct? Seeking for the approval.
That's correct.
So, the people that have signed on this memorandum did not approve the acquisition agreement, correct? Except for the MD.
By virtue of his position, he's the only person that could approve.
Okay.
And we know that the information contained in this document had already started being developed from the 6th or the 7th of July.
Yes. So you are saying that the MD didn't know anything about it until 8 July?
No.
I thought...
Okay. No, we are saying, you could see even in the previous email we read, Mr. Willemse was referring to the managing director when he said MD. That is why the managing director has also been charged. It's because even these were just formalities. Hence we are saying all these documents, because the managing director was already aware of this. So all these documents were simply created in order to legitimatize the transactions when it's going to be concluded at the end of the day, rather on the 19th of July 2022.
So the internal memorandum is also a vehicle to commit corruption and fraud?
That's correct.
Great. In the beginning I asked you whether you've done many fraud cases. Would you agree with me that to successfully charge someone with fraud, you need a misrepresentation?
And I've been talking about misrepresentation all along.
You need someone that acted on this misrepresentation.
Of course.
And you need, the third element is you need prejudice or potential prejudice.
That's right.
So you don't need the person that commit fraud, you don't need to prove that that person received money or any gratification. That offense is complete. Do you agree?
That is why when it comes to fraud, at least as far as the evidence is concerned, the actual prejudice that was suffered is 53,212,000 in respect of the asset purchase. So yes, that has not changed.
Okay. Now, keeping in mind those elements, the signatures on 250, they bound themselves, except, in fact, everybody, bound themselves on the information that appears on the internal memorandum. Would you agree?
I would not have a comment because I was not present when they were signing. So I would not know that they bound themselves on the information contained in the memorandum, because I know in terms of the evidence that Mr. Velemse was already involved. He even knew that this was going to be written already. So with the others, I cannot confirm that they bound themselves on this.
Okay, that's strange. You said this internal memo created a misrepresentation.
That's correct.
So the memo is the misrepresentation, the paying by NAMCOR of the 53 million would be the prejudice, correct?
That's correct.
Okay. Now, let's go to page 250 of that of the bundle.
250.
Yeah, just where they sign.
That's where I am.
Are you there? Okay. No, I thought you were back where
No,
talked about the misrepresentation.
No, I'm still on
Okay,
page 250.
still, okay. Keep it there. Mr. Dunaiski signed.
That's correct. The name appears there.
In your investigation, what did order mean?
Ordered, I believe, is the person that is requesting for approval, the author of the document in this regard.
The author. Is that what your investigation say?
You
The
asked,
author-
you asked me what it meant, and I explained it.
I'm saying in terms of your investigation.
The person who wrote the submission,
Okay.
if you want to put me in simple English terms.
And what does supported by means? In simple Oxford, or maybe not Oxford, English.
Supported, it's what it means, is to support.
Meaning, whatever I said there, I support that idea.
Yes.
I
Basically, is to put weight.
align myself.
Yes.
Great. What does recommended by mean?
Is the person recommending. And these words is what they mean. I'm recommending because this has been brought to me and I agree with the, basically it's agreeing with the submissions that was made, and therefore, is it a viable project or not?
Yes, but we have, according to your evidence, this internal memo is a misrepresentation. So whoever signed that agreement aligned himself or herself with that misrepresentation. Do you agree?
Not entirely correct.
Not entirely correct.
Not entirely correct, in a sense that some of the actors, they already knew, and hence we have been singing the song of conspiracy. So this was simply rubber stamped by some.
But Mr. Inambao, I just informed you the complete offense of fraud.
I am very much familiar with the offense of fraud. And
Fraud does not have, let me explain to you something. Fraud does not have an element of conspiracy in the essential element of the charged fraud.
And I totally agree with you. And let me tell you why I agree with you. That is why you see the offenses has been listed differently.
Yes.
The offense of conspiracy, it's a charge on its own.
I agree.
And the fraud component, it's also a charge on its own,
I agree.
which comprises of the elements of misrepresentation. And we are saying there was intention in these regards, which ultimately caused an actual loss
Yes.
to NAMCOR Trading.
I agree. If one follow your reasoning, then Dunaiski, Maposa, Willemse, Shufeni, and Mulonga would be guilty of committing fraud because this is a misrepresentation that caused a prejudice of 53 million to NAMCOR. If one follow your reasoning.
Your Worship, that is why some of the accused persons on this case, they are here, including Mr. Velemse.
Yes.
Mr. Mulunga's name as the person who ultimately approved. He's one of the suspects.
Yes.
Miss Olivia, she's a suspect.
Yes. For the fraud case, I agree.
Yes.
On your definition. Where is Maposa?
Your Worship,
On your argument.
I believe I am here to provide evidence as far as to whether Mr. Velemse is a candidate for bail and to demonstrate the actions of Mr. Velemse. As far as the directions of the investigations, I cannot, it's not my duty to say this one is a suspect, this one. Investigations, Your Worship, is still ongoing. And we know of these names. One of the grounds, Your Worship, we have provided is that they are still pending arrests.
do you say that Mr. Maposa and Mr. Shufeni will be arrested?
I have no answer to that question, Your Worship.
But if they was to be arrested, how will the accused interfere with them?
The same way, Your Worship, we know that one of the suspects we are looking for ran away few minutes after apprehending Mr. Willemse. At this point in time, I'm not confirming whether these are suspects or not, but I'm saying investigations are ongoing. These people are known to Mr. Willemse.
But I'll come back to that point, but you know, you are telling this court the accused or the applicant will interfere on people that he doesn't know whether they will be there or not, on people that is unknown to him at this point.
Your Worship,
It will be a suspect, correct?
when I testified yesterday, and hence, you know, it's not only one ground of, you know, of denying bail, Your Worship. There is several grounds that has been provided as to why denying bail. And I remember when I was testifying yesterday, I said due to the complexities of the transactions involved, especially in the money laundering, we are still following those transactions.
I understand, Mr.
So the suspects is not the only reason that was provided. There's many other reasons.
Yes, but Mr. Inambao, the witness, the applicant must address this, all these grounds for the court to make the determination.
Yes.
You cannot say there are others, not that one, there are others, not that one. You must address all of them. I'm just trying to address that aspect. Do you understand?
Because you want me to confirm if these are suspects and how the applicant will interfere. There's still other names that we are following.
You're missing the point. All right, let's talk about QMS, quality meat supply. My learned friend informed this court that quality meat supplies is a briefcase company. What is a briefcase company? Do you know?
Your Worship, as far as our evidence is concerned, quality meat supplies, among others, was simply used as an entity to launder the money, specifically the money that came from NAMCOR, or I mean the money that was intended for NAMCOR.
Yes. Okay.
So, as far as the briefcase is concerned, we know that this business does not have an office, because we visited the residence, Your Worship, during the investigations, where we found a residential address, Your Worship.
Point out a section of the law that says that if you have a business, it is a must that you need to have a business premises. Which law is that?
Your Worship, even if I can't point you out to that law, there is also no prescription as to whether people cannot have briefcase company. We are simply giving a definition of what this entity was at the time that we conducted the investigations. Okay. We are saying there's no physical structure that they can claim they are operating from here, yes. Meaning their business is simply being, you know, carried whether they go, whether in the car or in the house.
Okay. So that is your definition. It's saying that the only reason why you're saying it's a briefcase company is because it did not have a business address.
There was a business address, but
there was no butchery.
In terms of the founding documentations, there is an address which is listed there, the address which we visited, but there's no operations.
Yes. All right. Is a business address the only evidence that the business operated?
Not necessarily.
Yes. It is no doubt in this court's mind, and I put it to you, that Quality Meat Supplies operated as a business in terms of what is going on in his account.
It operated as a business, more so to launder the money.
Yes.
So it was used, or it was created as an instrument to, that was used to launder the proceeds of the offenses that we are here busy demonstrating to this court.
Okay. You said it was created. When was it created?
I cannot remember the exact date when it was established or when it was registered with BIPA.
Yes.
But I believe it was somewhere in 2021.
All right. Was it specifically created for money laundering, according to your investigation?
In terms of the founding statement, it was created, the nature of business listed there is livestock, selling of livestock, beef, and among others.
Here's the question. In terms of your investigation, was Quality Meat Supply specifically created to launder the money,
Your Worship, we are saying, in terms of the investigations, the proceeds from NAMCOR were laundered through Quality Meat Supplies.
That's your answer. Mr. Willemse testified that he had a business relationship with Mr. Malema, which you indicated yesterday was the beneficial owner of Quality Meat Supplies. Do you have evidence to show the contrary? Credible evidence to show the contrary?
Your Worship, our evidence, as I demonstrated from yesterday, shows that Mr. Willemse was involved in the acquisition of the assets from Enacon when he was in the employment of NAMCOR. From there, Your Worship, as a result of his involvement, money was paid to Enacon. That money ended up in the account. Part of it ended up in the account of Quality Meat Supply Eco Trading, and then from there into Quality Meat Supplies, and then into his personal account and into his business account. Your Worship, if we look at those account statements, and I know the account statement because that account statement starts from January 2022, I believe. You don't see transactions going to Mr. Willemse. It's only after the agreement or the assets were sold, or rather were bought by NAMCOR. The first payments to Mr. Willemse is money which comes from, as a result of those money which comes from NAMCOR. That's our evidence, Your Worship. And it has not changed.
Okay. Can you dispute that there was a business relationship between the beneficial owner of Quality Meat Supplies and Mr. Willemse?
Your Worship, all of them are our suspects. And we are talking about charges of conspiracy here. They are suspects. Although Mr. Malema is not here, he's a suspect on the case.
Can you deny or can you disprove that in April 2022, this business relationship between Mr. Malema and Mr. Willemse commenced for the buying and selling of meat products?
Your Worship, I don't have that evidence and I've never testified to that effect. What I testified on is the money that came from NAMCOR, the money that came from other entities linked to Mr. Malema, which was paid to Mr. Willemse. Your Worship, in addition to that, we had the opportunity of looking at the invoices that Mr. Willemse provided to NAMRA. We couldn't find any evidence of that. He would have provided them because he had ample time to look for those invoices.
Are you done?
I'm done.
Okay, so you have no evidence that it couldn't commence then. That's how I understand that whole story. You forgot conspiracy.
Thank you for adding it.
Yes. Now, the prosecutor informed Mr. Willemse that his version that he has sold meat and meat products to quality meat supplies is not plausible because it's impossible to have so. If you look at the amount that he sold meat to Mr. Malema, it was impossible to do that because it requires a lot of animals.
It's impossible to do because?
It's too much animals. You testified yesterday that you could not compare your heard statement with the statement that my learned friend.
We list our investigation files are at the office. So in order for me to verify, I need to have the two documents to make sure that they align.
Don't have a problem with that. So at the time of you seeing this document, you already had a heard statement of the accused.
That's correct.
And that is what I think that is the way, because the prosecutor insisted on, you don't have a heard statement, well knowing that the ACC sits with the exact evidence that the prosecutor is requesting my client from. That's unfair procedure in a trial, sir. Do you agree?
Your Worship, I don't know whether I need to answer that question because I was not prosecuting. I was not putting those questions. Here I testified yesterday and said we have those. That's what I said when I testified.
Because if, in the absence, if that document was present with you, I find it unbelievable that the state would insist that you don't have a heard statement, that's why you don't have the animals, while the ACC has it.
I believe you are making a statement and I'm just listening from you because I don't have an answer for you on that.
There's a duty to be fair to the applicant, both on the state and yourself. I'm saying that was unfair.
But it's also the prerogative of the state to decide on which pieces of evidence to disclose to you at the time, because I believe this is not trial. So the state can choose which documents to disclose and which one not to disclose.
Mm-hmm. Now, here's his version, the applicant's version. And he says that at a business relationship, Mr. Malema, both farmers, and he sold cattle, goats, and pigs to him, and that is why he received money from Quality Meat Supply. That is his version. What do you say?
Your Worship, I dismiss that version because I already indicated if there was that agreement from April, Your Worship, you would have seen payments going to Willemse in April. Those payments are not there. It's only after, Your Worship. In fact, the payment from NAMCOR was made on the 19th of July. Already on the 20th of July and the 21st of July, you see this money going now to Mr. Willemse, who was at the time involved in the process.
Yes.
So we are saying that money is direct proceeds from the money that was stolen from NAMCOR.
Okay. So, I just want to get clarity. The 9.5 was sent to which company?
Eco Trading.
Who's the owner of the company?
It's Maneka.
Okay. It is sent to where? QMS.
Of which Maneka is also the beneficial owner, so it doesn't really make a difference because he controls the two entities.
Doesn't really make a difference, yes. The 9.5 million that was sent to NAMCOR, to Eco Trading. What was this description on the bank for Eco Trading to receive that money?
Your Worship, I can confirm if I have the bank statement in front of me. I don't want to guess when we have the bank statement.
Yes, I can tell you it's fuel. Page 2, the record of Eco Trading starts on 272. You can have a look through them until page 279.
272 in the bunch I'm having here is eco trading. Is it the one you want me to look at?
Where did the money go to from Enercon?
Oh, no, I wanted to verify if you wanted me to, because,
sorry.
You were asking me the reference that of the funds of the money that went to Mr. Willemse.
No, I didn't ask you that.
You asked.
But I hear what you say. Yes, I want you to go there. Statement.
Okay, so what is it that you want me to address?
What was the reference on that back statement from the 9.5 million paid from Enercon to Eco Trading?
Your Worship, the answer is on page 276. Date is 19 July 2022. The reference is Enercon Namibia fuel payment, or rather fuel PMT, which I can only assume is for payment.
Okay. In your investigation, what kind of company was Enercon? What did it do?
Enercon, among others, was responsible for supplying fuel petroleum products.
And Eco Trading?
Eco Trading, I cannot remember the nature of the business activities, but definitely it was not registered with the Ministry of Mines and Energy as either, on any, to become anything relating to the supply or wholesaling of fuel product.
So they don't supply fuel?
As far as the registration documents, as far as the records of the Ministry of Mines and Energy are concerned, they had no licensing with the ministry.
Okay. But if you look at this, the statement of Enercon, rather Eco Trading, you see there are a few payments received from, as reference, fuel payments. Do you see that? If you quickly glance through.
Your Worship, this entity was owned by Victor Malema, and there's a number of transactions between Enercon, Erongo, EcoFuel, quality meat supplies, and so forth and so on. Hence, we are saying all these entities, they are the branches of the same tree, because they are owned by people who are related. There are transactions, multiple transactions among themselves. So in the description, this is somebody who's sitting in front of the computer. They can decide to put description. You can even put payment to Mr. Inamba while the money is actually not going to Mr. Inamba.
Yeah, we will follow that transaction and see in your account that it will actually reflect there. But what we know in terms of payment is that the same amount reflect or is debited in Enercon account. It's not so?
It's correct.
Yes.
But remember, the description can change. The description does not have to be the same. There's a description of the person paying and the description of the person receiving the payment.
Okay.
And all those are manually inputted by the person that is making the payment.
In this account, who did the prescription? Who made it?
In this account?
Yes. You said I must remember the difference. You tell me, what's the difference?
No. The difference, that has nothing to do with who made the payment. That's the question which you asked me. Who made the payment? So I was trying to tell you that the description on the two accounts can be the same or it can be different.
I hear you.
Yeah.
But what we have seen here is a bank statement that referred to fuel payment.
That's correct.
Okay. You told this court, the very first payment, when the 9.5 million hit their account, money was ciphered through to Mr. Willemse. That's your testimony.
That's not true.
I think you said that, Mr. Inamba.
That's not true.
Are you distancing yourself from that statement? You know why you say it's not true? Because now you realize when you look at this at the bank statements, then it's not true.
No.
Yes.
I said on the same date. And remember, during this application, the concentration was on the evidence towards the applicant, which we have. And I did indicate in my examination in chief that as soon as the money hit the account of Enacon,
yes,
there were two specific payments that were made immediately. It's a payment to Onyeka of 3,613,000 and the payment of 9.5 to Eco Trading. And then from there, I said I will concentrate on the 9.5.
Mr. Inambao, even with the evidence in front of you, you're still not correct. The first payment was 1 million.
No, you are
to
totally wrong. Because
I
was talking about the money which came from when the money hit the account of Enacon. I didn't talk. I said there's no 3.6 here. I just spoke about the 3.6 and the 9.5.
Okay.
So of course, from this statement, you can see there's a 1 million which went to Venus as the first payment.
Yes.
It's only that the statement does not provide the timestamp as to when these transactions was done. And the second payment is the payment which went to Quality Meat Supplies of 1,470,000.
It seems to me that is the norm in that company, that money comes in and payments are made. It looks like the norm.
I would not say it's a norm. From investigation perspective, this was urgent because there were bribes. So the actors were waiting for their share of the pie.
If you look at the statement, Mr. Inambao, page 2, let me start with page 273. I just want to take two quickly.
270?
273, on the 2nd of February, there was a payment for services, 130, and then immediately after that, 125,000 went out of the account. Looks like a norm.
I believe I'm lost here. You are
lost in translation.
You are saying 273.
Yeah, page 273.
273.
Yes.
You said the date is February, because the statement I'm having here.
2nd April. Sorry.
Oh yes. So I wonder who was lost in translation.
That's why I'm saying maybe I got you lost. Just stay focused.
2nd April, which is the third transaction, or 130, which is the fourth transaction.
Yes. Immediately after that, almost 90% of that money is paid out.
Maybe you can say the date. It's cut off in the court.
It looks like the 2nd. But the amount is 130,000 in the credit line. It's the first credit that appears.
Okay.
And the second one is 126. You see that?
I see that.
Take another example. Page 274 at the bottom. There was a logistic payment that is on page 274. Not to make sure you're not lost in translation. 30 May 2022. There's a 3 million, and then the same day 3 million paid out. You see that?
I see that.
Seems like the company, when money comes in, payments are made.
Yes.
This company.
And hence we are saying this account was used specifically when it comes to the money from NAMCOR. It was being used to make sure, to disguise the origin of the funds, basically. Yes, that's why you see, when it comes to Enacon first, it hits the account of Enacon. From there, it doesn't go directly to where it's intended to go. It moves into Eco Trading, and then from there you see the disbursements happening.
Yes, but this norm was well before July.
Yes,
and the money, as you say, hit the account.
Yes. Yes. But what is interesting is you don't see payments going to Parkwood.
To Parkwood.
Or Mr. Velemse?
Sorry?
I'm
There's no
saying
payment to
what is
Parkwood.
interesting is, in this period that you are mentioning from April there until the payment of 9.5 in July, you don't see money going to...
Yes. Are you saying that you can only explain a payment if you receive more than one payment from a company? Because if you only receive one payment of a company, corruption.
Not necessarily.
Yes.
There's a lot of factors to consider, and we have demonstrated so.
I agree. There's a lot of
Yes,
factors.
and we have shown the factors which we had considered during the investigations to come to that conclusion.
Yes. So to come back to the QMS, quality meat supply. The fact remains that 150,000 was not received from NAMCOR. Do you hear me? By Mr. Williamson. On the day the agreement was signed.
Do you have the statement of, can you refer me to the statement of quality meat supplies?
You will find it on page 280. It starts there.
Thank you. And what was your questions again, Mr. Isaacs?
That's the problem.
I want to make sure, because a couple of minutes has passed while we are looking for the records. I want to make sure that I give you the answer that is deserving.
Okay. 150,000 in terms of the evidence before the court was received by Mr. Willemse from Quality Meat Supply.
Yes.
Is it?
It was received from Quality Meat Supplies.
Yes.
Your Worship, and if I can draw your attention to 15 July.
Yes.
I believe it's transaction code 155. But I don't trust this transaction code because you would see that they actually they are repetitive. So
you don't trust codes?
No, if you look at this bank statement, you would see they are repetitive, meaning it's a description for a specific payment. So if I say code 155, there's a lot of one other 55. So hence I'm relying more on the date.
I see.
Thank you very much.
Okay.
So Your Worship, you would see that there was a payment that was made to Mr. CP, that was made to CP Velemse, Game and Goats. But what is interesting, Your Worship, is that before that payment was made, on the same date, there was a payment in the same amount that was received from Erongo Petroleum.
Okay. So we know now that Erongo Petroleum did not sign the asset purchase agreement, correct?
Although they didn't sign asset purchase agreement, its company is owned by the same family. And there's flow of money between these entities.
I understand that. I see you're excited about, you want to repeat everything. But this bail application you could have finished in a few hours. I'm really trying to minimize my cross-examination, specific answers, and we move on.
Of course.
If you look at the bottom of that, the top of that statement, 27 May, you see there's an order payment.
That's correct.
Of 100.
That's correct.
2 days after that, the exact amount is paid out.
Let me make sure I'm following. You said 27 May, right?
Yes.
There's an order payment of 100,000.
That is correct.
Which is a credit.
Yes. So money came in. The
Yes.
very same day, sorry, not 2 days.
Yes.
The very same day.
Yes, on the same date,
Money goes out.
that money goes out.
You see that?
Yes.
Okay.
And that money goes out to Panduleni Farming, which is an entity
Yes.
owned by the husband to Jennifer Mkwaya.
But in May there was no corruption, or was there?
We are saying already the conspiracy started in October 2021.
But Mr. Inambao, you said the proof of the conspiracy, the money was laundered. When did the 9.5 million hit Enercon's account?
No. I think you are missing the point here.
No, you are missing the point.
I've testified the conspiracy, as far as the earliest evidence we could get, dates back to 26 October 2021.
But you haven't mentioned Panduleni as part of the conspiracy.
No.
Did you?
What do you mean I didn't? We
Did you
have
mention-
indicated, in fact, that's why I'm trying to take you back to the details. I told the court that on 26 October 2021, which is at least a couple of months before this, about 6 months,
7 actually.
Yes, 7 months before this. That's when Enercon made a resolution to open an account where Ms. Mkwaya was given access to. That was before Enercon became a customer of NAMCOR in November 2021. So we are saying by then the conspiracy was there. We know the plan to acquire the assets. As the earliest evidence we have is 22 April, which is before this.
Mr. Inambao, are you saying that $100,000 form part of the conspiracy?
As far as the investigations is concerned, definitely. In fact,
Oh,
if you were to look at the charges of Ms. Mkwaya and her husband, you would find that one also.
So the 100,000 is part of the conspiracy.
It's part of the offenses we are investigating.
It's part of the conspiracy. I'm asking.
I cannot say it's part of the conspiracy. I'm saying this is part of the payments that we are investigating. Okay. Conspiracy already started even before 26 October, because there would have been engagements before documents were written or before accounts were opened. 4
July. That is before the money, the 9.5 million was paid. There's a payment of 134,000. Can you see that?
Yes.
And the ink is still not dry in the bank. Paid out. You see that?
Yes, and you know when you are talking about
this entity, just wait. Is
in fact what I wanted
Oshali
to
paid the money. Wait.
Yes.
And it was drawn. Is Oshali also part of the?
It's one of
conspiracy
the.
theory?
It's one of the same family.
No, I'm asking. Is anyone from Oshali or Oshali itself? Is it part of the accused?
Oshali Smaneka is the beneficial owner as well.
I'm asking. In this charge before this court, or any charge in this case, is Oshali as a company an accused, or the beneficial owner of the company an accused?
Definitely.
And you said that 134,000 was also part of the conspiracy.
No. We can't say this was part of the conspiracy. This is Simaneka moving money from this account which he controls into this account. So it's not like this money was being paid to a staff member of NAMCOR. Had it been paid to a staff member of NAMCOR, then it's something else. You have Simaneka controlling the accounts of Quality Meat Supply. You have Simaneka controlling the account of Oshali. So he's basically making transactions between the two accounts.
So your song,
so what I
conspiracy
want
doesn't apply here. The song conspiracy doesn't apply here.
No. I cannot say that it applies there.
Okay.
And we have identified in terms of the charges, the transactions that we are concerned about.
I see. But one thing I can tell you, if you look at this, if you look at this agreement, money comes in and almost money come out. That's a trend in this bank statement. Do you see? Or do you hear me?
I hear you, but as far as the money that we are able to, where the accused persons and the applicant is charged, we are saying those are bribes, gratification which they received.
Yes. Now, Mr. Inambao, as a seasoned investigating officer, both in the Namibian police and the ACC, you would agree with me that direct evidence is stronger than inference, evidence based on inference. Is it correct? Circumstantial evidence. Do you hear me?
In terms of the law of evidence, direct evidence is always better. But in this regards, we have the evidence.
Yes.
We have the evidence which points to the applicant's involvement. We have evidence indicating how the applicant received the, bribes.
Yes. In this 150,000 specifically, you would agree with me that the evidence pointing to a bribe in respect of Mr. Willemse is circumstantial.
Your Worship, we know that on the 15th of July, 2022, that is the very day the agreement between NACON and NAMCOR was signed by NACON.
Yes,
and then from there, you start to see money flowing into Mr. Willemse's account. The person that was responsible, partly for the arrangements of the acquisition, or at least for negotiations.
Mr. Inambal, the charges my client facing is that he received money, money from NACON or Irongo. I'm putting it to you on this transaction, and that is for the asset purchase agreement. I put it to you that in respect of NACON, the evidence here is circumstantial.
Your Worship,
agree?
These are not ordinary people. These are executives that we are talking about here. It's people who were executive. This is organized crimes at its best, Your Worship. The people planned. They did not want to leave trails as to where the money was coming from. That is why they were disguising it as having, as them having delivered or rendered services. They could have paid the money directly from NACON's account, but they were afraid.
Okay.
So this was simply disguising the origin of the funds. That's how we are looking at it in terms of the evidence that we have. So it's not circumstantial.
Oh, okay. Not circumstantial. Because maybe on that note, I see it's 4 o'clock. I still have a lot to deal with this witness. May I ask if we can roll this matter over to tomorrow? If there's no objection from my colleague's side. I'm sure he will maybe object when we get done with this.
Your Worship, I just want to make sure if I don't have anything tomorrow. No, it's in order. It's in order. Is it 10?
We can resume at 10 o'clock, so the matter is adjourned to the 18th. The 18th of September for continuation of the bail application. We are to commence start at 10 a.m. The applicant is remanded in custody.
As the court pleases. The court pleases.
We may adjourn.